Yeah, so hopefully everybody had a good holiday weekend. It was successful for me because my family and I, at least two of the boys, two that are in the Army, we met down and took in the USC football game down at the Coliseum. And sorry if you're a Notre Dame fan, my apologies.
Fight on.
That's right. It was a good time. Okay, well, let's get underway. I want to respect you guys' time. Thank you for being on the call. I'm going to share my screen here for a second. I want to show you, before I share my screen, if you read the quarterly newsletter that comes out from the Division of Real Estate, they've made some interesting points over the past, well, they always make some interesting points, but talking about us reviewing as licensees, not even as brokers, they're talking to you as licensees, reviewing the administrative rules, statute, and then the administrative rules. Who even knows where to find those? Dan, do you know? Good.
No idea.
Because I'm going to show you this morning.
That's why we hired you, Matt. You're supposed to know to look.
Yeah, well, what a coincidence. I do know. So let's see here. All right. If you go to the Division of Real Estate, realestate.utah.gov/real estate, you will come up with this lovely little updated website that's the update in the past year. And if you come down to statute and administrative rules, here's the starting point for all of our, well, I would like to say our headaches, but hopefully we see some of these things as a positive and weeding out some of the bad actors. So the Real Estate Licensing Practices Act. So just, I've talked to so many agents about this and they don't really even understand. So the legislature enacts the Real Estate Act. That's right. So that is the law. Then they have the entity, which is known as the Division of Real Estate, for applying that law. And the Division of Real Estate creates administrative rules of how to implement the law. So if you click on this and you go to the administrative rule, you can go through each page of the administrative rules in detail. And trust me, it gets very detailed. And I would just say as a general rule, it's a little more, for the most part, ambiguous. I mean, they use general terms. They don't get into the specifics. They kick it over to the Division of Real Estate and say, now make it all work. So the Division of Real Estate says, great, we're going to create some administrative rules. And here they are. And they go for pages and pages and pages. I'm not going to bore you with all of those. But I did want to share with you, since I just went through this again last week, I had a Word document that was so marked up and had notes on it and everything about the administrative rules. And then somebody pointed out that the version I have is a couple of years old and they've added a few more rules. So I went to do the same thing and started this process. And we're not going to spend this morning talking about all of the administrative rules, but I figured what I was going to do on each one of these calls is cover one of those rules at the front end, kind of as a get acquainted, get the conversation going. So the first administrative rule under the affirmative obligations, notice that it starts out, it says an individual licensee shall, not, hey, if it feels good or if it fits into your schedule. They don't make that equivocation. They say you shall do the following. And the very first thing is your fiduciaries. I've asked this of agents and brokers, and I'm like, hey, what are your fiduciaries? And you get about 2, maybe 3 if you're lucky. So here they are. You have the fiduciary, which is translated a legal responsibility for loyalty, for obedience, for full disclosure, for confidentiality. And then if we scroll down, reasonable care and diligence. And this is a big umbrella item that they can cram a lot of stuff under. And then the next to last one, holding safe and accounting for money. And then the catch-all, item G, any additional duties created by the agency agreement. So they didn't want to go into all the gory details of how many things we should be paying attention to, but just a kind of a teaser of some of the main ones. So like I said, I'm not going to do an exhaustive discussion of this, but I think it's kind of interesting when we look at our fiduciaries. What does it even mean? Dan, I'm going to pick on you because you were on the call this morning and you're my hall mate. What is in your definition? There's no right or wrong answer for this. What is your definition of reasonable care and diligence? Yeah, right. You like that one?
No, that's like I mean, that's almost as bad as G, additional duties. Right?
Yeah, you're right. Yeah.
I really don't have anything to say other than, the primary answers of whatever. Like, I mean, what's reasonable care and do? I mean, you act as an agent, right? You act as someone who's been in the industry and knows how to treat a client. You tell them within a certain amount of time the information that you've learned, right? It's somewhat of a catch-all, I think, right?
Yeah. Yeah. I mean, this is a good one. I picked on that one intentionally because, like I started off with, this isn't a broker issue. This is an individual licensee issue. It's also a broker issue, but it's an individual licensee. And when I've had to explain this to agents, you try and boil it down to something digestible. And it's something like this, Dan. I would say, your fiduciary of reasonable care and diligence is somebody is paying you, and you don't get to say, oh no, the seller's paying me. No, through the MLS agreement, through your broker, through your ICA and your contract with the client, they're paying you. What is a reasonable expectation for you as the professional in navigating this process of acquiring real estate? And so you can't sit there and as a licensee and say, gosh, I didn't know that. I mean, you can, but that's not reasonable because you're the professional who is licensed, who's been hired and being paid a lot of money. So reasonable care and due diligence is, in my translation, is to that paying attention to the details. Simple example. Do you know your dates in section 24? You better know them. You better be communicating with your client. That's part of your due diligence, right? Do you know the terms of the contract in regards to earnest money and when it needs to be in so that there's not a breach in contract? Items like that fall all under this reasonable care and due diligence. Now, we're not expected to be attorneys, but we don't have 500 contracts either. We have, 4 or 5 frequently used contracts. And I would just say, if you're a practicing licensee, you probably ought to know those contracts to a decent level, because that is reasonable care and due diligence. So, all right, that's not what we're talking about today. That was just a teaser to get your minds jogged and thinking about some of the important things. Okay, I've had this question a lot lately, and so it becomes a topic for me. Whether you're the buyer or whether you're the seller, you go under contract with a REPC, and people, you go through your due diligence, you get your appraisal, you work on your financing, and as luck would have it, sometimes the deal just doesn't work out. We get to the settlement deadline and somebody doesn't perform. The buyer does not perform. Funds do not arrive. Where are we? Where are we with that contract? Buyer or seller? Anybody? Crickets. Okay, that's it. Don, you're the only one with your video on. I don't mean to pick on people, Don and Dan. You're the only two with your video on. Thank you for doing that. But Don, if you were representing, I'll narrow it down. If you're representing the seller and the buyer doesn't perform, where do we go? What do we do?
Well, I think you still need to close your side so that you're not in default.
Okay, good point.
I think there's somewhere in the contract it says the lender's funds have to be there by the settlement deadline.
Yeah, all the funds except for the loan, all the things that are required are to be there, yes.
Okay. So if settlement deadline comes and goes and no funds have been produced, then I feel the buyer is in default at that point.
Okay, you are correct so far. I'm going to press you a little further. So what do we do now as a seller? Do we go and get a new buyer?
Well, it's certainly up to the seller they have that choice. I think though, you need to have a little conversation with the other agent and with the lender to see what the holdup is. Probably write up an extension if you think you can save it.
Okay.
If you can't save it, then yeah, I guess you're looking for a new buyer.
You are, and I'm trolling deep and wide with my questions here. This is the very crux of why I wanted to cover this morning.
Earnest money. Hello.
Who's that? You're showing his iPhone.
Oh, good. I'm glad it's Kelly
Hi, Kelly.
in St. George. How you doing?
Yeah, so Kelly, say that again. What was the comment?
Earnest money. Hello. We got to figure that out.
Okay, so
Yeah.
a default, let's piece this together. If you go past settlement deadline, a default has occurred, right? Everybody agrees with that. The buyer did not perform. There is a default. Here's where it's still surprising to me, even to this day. A lot of agents outside the company, a few within our company, still have this misperception that because you went past settlement deadline, that the deal's dead. It's not. It's not. A default has occurred. And I'm going to get into just briefly into a court case here to show you why this is so important. My point of all this, Don and Kelly, is I have trained, or have asked, I should say, that sounds horrible. I have asked our office manager staff to make sure when we do go past a deadline to reach out to the agent to get the lay of the land, and then to ask for a cancellation, buyer or seller, a buyer's notice of cancellation or a seller's notice of cancellation. Why?
Got to have it in writing.
Okay, but all right, I'm going to press further, Kelly.
Yeah,
I'm just going to call you iPhone, Kelly.
that's fine. You can do that. I go by all kinds of names.
Yeah.
around
Okay.
here.
All right. All right. But why do we care if it's in writing?
Because we have to have it to find out. Well, we know who's in default, but we need to have it in writing, and then we have to figure out who gets the earnest money.
All right. So
That's
earnest
why-
money. So we
Yeah.
started off with there's a default, and earnest money is only one of three remedies. The other remedy, Dan, that's number 2.
They can sue them.
Sue them for specific
Damages.
performance.
Uh-huh.
Or the third one is sue them for other damages available.
Other damages. Yeah.
Right? And so we kind of default because it's the easiest remedy, because, and that's why so many people say, oh, earnest money, because that's the most common, but it's
Right.
not exclusive. Dan, go ahead.
Yeah, we had this come up last week with one of our agents where they had a buyer who wanted to cancel the contract, and essentially the buyer was just getting cold feet. We represented the buyer, and the agent's assumption was like, oh, we can just get out of it, and maybe we lose the $500 earnest money deposit, right? And the seller, they actually had real damages here.
Yeah.
The seller is in a divorce, and the seller has a court order to sell the property by, it was the Friday of this week, I think maybe have been 2 weeks ago. But anyway, actually it was last week. To sell it by Friday, or he incurs an additional $5,000 fine or penalty, whatever. And I'm like, well, if your client doesn't want it, that's, let's figure out what we can do to help them out of it. But, there's a real possibility that they're on the hook for way more than $500.
Oh,
They
man.
might be able to sue for performance, and they certainly sound like they have some real damages if your client doesn't perform. So your client needs to know that it's way more than $500 likely on the line. And let's get to the bottom of, is this just cold feet, or is there really something going on to where they can't or shouldn't be performing on this contract, even if it costs them $5,000?
Right.
So, this came up just a few weeks ago.
So thank you for bringing that up, because you hit the three-headed beast, right?
Yeah.
Yeah, go ahead, Kelly.
No, I was gonna say, why in the hell would that buyer's agent accept such a pittance for earnest money? They have no skin in the game, none. That's why they walked.
That is a good point, but I'm not going to address that this morning.
Okay.
I can't handle I can't fix all the crazy out there. But
Oh, come on.
here's the thing. So the three remedies: earnest money, suing for performance, and other damages. So we all know earnest money. That's pretty easy. I don't need to discuss that so much right now. The second one is, I've heard so many agents and other brokers say nobody wins when they sue for performance. That's an absolute lie.
Okay.
If you talk to any number of real estate attorneys, they say it's challenging, but it does happen, and it happens fairly regularly, especially when somebody has more than one house. That tends to come up in the conversation. If a judge is faced with kicking somebody out of their house and they have nowhere to go, it gets a little more challenging, especially if they have kids and extenuating circumstances like that. But oh man, anything aside from that is pretty fair game. The third one, damages, and I wanted to take just a minute and talk to what Dan was saying. This one is kind of, it's kind of the scary one, right? Because unless you're doing small claims, which the limit is $11,000, which is getting to be chump change these days, right? With the cost of everything. If you sue for performance, if you go over $11,000, you're going to district court, right? And if you go to district court, your filing fees in the neighborhood of $3,000, $3,500 just to get on the docket. Then you have to retain an attorney. Then you have to go through deposition. I mean, you do your first court appearance where everybody says, yeah, he's the jerk. And they say, you're the jerk. And who's representing the jerks? And then you go into the discovery phase and you do depositions, and your billable hours for attorneys keep going up and up and up, right? And then the average right now in district court is about 4 to 5 months before you even start having your hearings, right? So this becomes really expensive. Now, outside of the court costs and the annoyance of that, what are those damages? Is it possible me as a seller could say, you know what, I went with this guy's offer because he told me he was good for the money or whatever the thing is, and that turned out to be a falsehood or whatever, and I forewent another buyer who was a cash buyer who was willing to pay just a little bit less, and now he's gone. Are those damages? The answer is yes. Yes, they are. Especially if he has a contract showing what the offer was, right? And so you can really ratchet up the costs of that third option. And oh, by the way, Section 17 of our REPC says when it does go to be litigated, if you don't prevail, you're going to catch not only your own attorney's fees, but the other side's. And that's the X factor, right? And you can get $30,000 to $50,000 in attorney's fees like that, right? In addition to the damages, right? So we should not treat those things lightly. All right, I'm off my soapbox. Okay, well, to the question of why to cancel. I have on my screen here, hopefully you can see it. It is a Utah Court of Appeals case, load zone marketing versus Dennis Clark. And this is going to, I hope, demonstrate a couple of things. It's just, I won't like read the whole thing. I've highlighted a few sections, but it's going to point out a couple things. And one of the most significant, I'll tell you two of the most significant. One, you need to cancel, whether you're the buyer or the seller, and we'll come to the reasons why. And this Utah Appeals Court reaffirms that a contract does not die for a reasonable period of time after settlement. Now, Don's a reasonable guy. So Don, what's a reasonable period of time for you? I love it when the courts use a term like that. The contract's going to live for a reasonable period of time. How do we define that?
Well, I think it's subjective. I'd say, I don't know, maybe a week.
The court makes this point, yeah, well spoken. It depends on the circumstances, but it's kind of under that reasonableness doctrine. What would a reasonable person in that situation have an expectation of? In this case, it was 4 weeks. 4 weeks. Okay.
Yeah.
All right.
I was going to say, yeah, 30 days.
Yeah. And you know what? It could be longer depending on the circumstances. But my point
but you
is,
need to just get it all in writing.
thank you. You're jumping ahead. You're jumping ahead, Kelly.
That's the way I am.
All right. So, you know, this was a 2014 case. Clark agreed to buy a property from Load Zone. He had made it condition on financing. He went through and tried to get financing. He went past his financing deadline and was not able to get his financing, right? And then after the settlement deadline, after the settlement deadline, he canceled. And basically Load Zone was going like, listen, we want to enforce the contract because we don't think he really tried to get it. And not only that, the terms of the contract are specific on canceling based on financing. And this is where it kind of gets interesting, right? You'll see terms like this when you read court cases. The four corners of the contract, is it unambiguous language? You know, did the parties operate in good faith and reasonableness? And all these things come to light in this case. All right, so in paragraph 10 says, unlike the right to cancel in section 8.3a, which specifies that it must be invoked, meaning the cancellation, before the financing deadline, paragraph 8.3b does not restrict either party's right to cancel to a specific time frame after the closing deadline passes, right? So we're not quite there yet, but even there, the court is saying the contract's still alive. Otherwise, why would you have the right to cancel after the closing deadline passes? All right, and then they make reference to the 3 remedies in section 3 of the REPC, or section 16 of the REPC that we were just talking about. And let me get down to the nitty gritty here. Now, this is where the appeals court kind of chastises us as practitioners and parties to the contract. These provisions demonstrate that the parties were capable of drafting specific deadlines for contract cancellation had they intended to do so, and they cite some other case law. And then here's where we start to get this. The law implies that notice must be given within a reasonable amount of time. They cite another case law. If a contract fails to specify a time of performance, the law implies that it shall be done within a reasonable time under the circumstances, okay? All right, so then it goes down, what constitutes reasonable time depends on the circumstances. Again, if you ever read court cases, they're always citing other case laws here, case law there, case law. It's kind of a labyrinth because you then go read the other court cases. So in paragraph 16, it says, finally, reading the REPC to allow cancellation 4 weeks after the settlement deadline does not, as Load Zone asserts, prevent the seller from knowing when non-performance under section 8.3 ends and a breach of contract under 16.1 begins. If a buyer fails to deliver the proceeds of the loan to the escrow closing office by the closing deadline, he has breached his purchase obligation, and paragraph 16.1 allows the seller to cancel the REPC and retain the buyer's earnest money, maintain the earnest money in the trust account and sue for performance, or return the buyer's earnest money and pursue any other legal remedies. So I want to stop there for a second. We knee jerk into a lot of these things, right? And Kelly, I'm glad you brought this up because we like default to earnest money. But if you read section 16 carefully, if you return the earnest money, you lose other remedies. If you want to sue for performance, you better keep that earnest money in the trust account, because if you don't, you lose that remedy. Did you know that?
Yeah.
Yeah.
Mhm.
So
Yeah.
what have we seen in the past year when people were writing crazy offers, right? Earnest money to be released to the seller. Think about that. If the earnest money is released to the seller, what remedy do they have? They've now got 2. They lost the ability to sue for performance because that earnest money, per the specific unambiguous language of the contract, required it to stay in the trust account. So the words in the contract matter, and especially when they're unambiguous. And that, you guys, is unambiguous language. All right, so coming full circle to this case, what they said was, hey, listen, the contract in 8.3a says, as a buyer, if I want to protect my earnest money based on financing, I need to provide cancellation before that financing and appraisal deadline, right? Everybody understands that. But what the court did then say was in section 8.3b that they can cancel afterwards. And if you've read your contract, you know this. If you cancel based on financing and there's no restraint on the time, if you cancel based on financing, the only remedy that's available to the seller is what? Anyone?
Say that again.
if the buyer cancels based on their inability to get financing, what is the only remedy available to the seller?
Earnest money.
Earnest money.
Yeah.
Earnest money.
Yeah.
And so in this case, it's kind of interesting because they canceled after the settlement deadline, but they canceled and said, we're canceling based on our inability to get financing. There's a lot of argument between the two sides. They were going to depose the lenders and the agents to determine it, but the appeals court said that really doesn't matter. They're the ones that gave an unambiguous cancellation, and the contract did not restrict them from canceling based on financing, even after the settlement deadline. And the only remedy that was available to the sellers was the earnest money. And they wanted to sue for performance because they knew the buyer could perform. So why share this case? If you're representing a buyer, think about this case. If you're representing a buyer, did that serve them well to send a cancellation based on financing, even though it was after the settlement deadline? Yeah. I mean, whatever it was, $3,000. I can't remember what the earnest money was. It wasn't a huge amount of money. That was the only remedy available to them. Okay. What about the flip side of the coin? If you have a seller, why would we want a seller's notice of cancellation? What are the benefits to the seller sending over the settlement deadline passes, right? What is the benefit to having a seller send to the buyer a notice of cancellation for non-performance? Why?
So they can go ahead and resell it.
Thank you. Yeah, because what we just read was that contract, until it is canceled, still is alive for a reasonable period of time. And if you went and got another buyer with a contract, you just created exposure for your seller because you just put them under contract twice, right? And guess who's now in the liability and the money game? You are.
You are.
You are. All right.
No double contracts, please.
Yeah, right.
Hey, Matt, I'm sorry. I think I missed something there.
It's okay, Dan.
So if you're the seller and so what information do you have to cancel the contract when your buyer can't get financing?
Okay.
At that
So
point, it's not your contract to cancel, right?
Well, so sorry, I should have connected the dots. Using this case as kind of the example, everybody agreed they went past the settlement deadline. Once settlement deadline is passed and funds are not produced, who has defaulted?
Got it.
The
Okay.
buyer has.
Yeah.
And at that point, the seller could, I would go a step further, the seller should proactively, again, Don made a good point. If you can resurrect it, fine. Yes, we all agree. But if there's no chance of resurrecting it, the seller should cancel because it preserves all three remedies in section 16, right?
Yep.
If you don't, and the buyer then, even after settlement says, yeah, you know what, we know our $3,000 earnest money is gone, but we are canceling the contract because we weren't able to get the loan together. Now your only remedy is earnest money because the buyer canceled the contract. The contract in section 8.3b and the interpretation of the court says, yeah, you can cancel any time. And if you say it's for financing, your only remedy is earnest money as a seller.
So canceling the contract from the seller's perspective does not release the buyer from their obligations, whether it be earnest money, or you can still go after for performance, or not for performance, I guess at that point, but you can still go after for any.
Actually, you could, Dan. That's my point. If the buyer didn't notify you of anything, you went past settlement deadline, you have a conversation with Don, who's the buyer's agent. He says, yeah, you know what, my guys weren't able to get financing together. That is not notice. That is not notice, right? And so if you as the seller's agent went to your seller and said, hey, I'm a good agent, I want to protect all of your rights under the contract. If we cancel now because we have a suspicion they could perform, or if we wanted to sue for other damages or remedies available at law, we need to cancel now before they provide a cancellation, right? Because it preserves our right to all three of the remedies in section 16.
Okay.
So the subtleties of the contract, and they're probably not a big deal until you're in a big deal where the stakes are high and you should have known these things, and your buyer or seller says, how come you didn't exercise reasonable care and due diligence on my behalf? So see how I tied it all back together?
Then you get sued.
And then you get sued.
Of course, I wouldn't know about that. Never did. Never.
Oh,
have.
I
Never
would. Yeah.
Hey, thanks. I gotta run. My phone has to go. Sorry. Bye.
Okay. Thanks, Kelly.
Thank you.
So this is my point, you guys. The words in the contract matter. Don't allow yourself to adopt the herd mentality of, I could throw a number of things at this. Well, everybody understood what we meant. It's never going to fly when you litigate, right? Or I didn't know that. That's not going to fly either. And on the positive side, if you can share some of these things with a client, they tend to become repeat clients because like, man knows his contracts. He really protected me. I would have had no idea that, I was going to lose out on remedies or whatever the case may be. This is one of many examples, but I think it's an important one. And I think it's a way for us. We're always looking for ways to set ourselves apart from our clients. And I think everybody on this call this morning can understand what was said. You don't have to be a contract nerd like I am and dig into the contracts. You just need to come onto this call and digest a few points and make it part of your library of knowledge, so that when situations come up, or if a seller says, well, what happens if, right? You don't always have to wait until an actual legal proceeding takes place. We get these questions in listings. Well, what happens if we accept this offer and this happens? Or you can sit there and say, well, it's kind of interesting. My years of experience have taught me these things, and you share with them, and all of a sudden, like, man, Don knows his stuff. Don knows his stuff. So, all right, that's what I had for you guys this morning. So the takeaways are, let me just restate them. A contract lives past settlement deadline. If nobody cancels, it lives for a reasonable period of time. That reasonable period of time is subjective. We know it can be at least 4 weeks because we have a case law that was for 4 weeks. The second point is, if you're a buyer and you go past settlement deadline, and it happens to be on financing, then cancel based on financing. Your only exposure at that point is earnest money. That's it. And then if you're a seller and somebody's gone past their their settlement deadline and there's no chance of resurrecting the deal, proactively cancel the contract. 2 reasons. 1, you don't want to put your seller in jeopardy by having them under contract with 2 people, 2 valid contracts. And 2, it maintains all of their rights as far as remedies in Section 16 if you do so. Okay? Anything you guys are seeing, anything you have questions on, or anything you want me to prepare for our meeting in 2 weeks, our Zoom call? If you do, if you have something that you've run across, I literally have a spreadsheet with like 40 or 50 different topics. And so I just go through the ones that, and I make entries as I go during the week, and I run across the issues. And so it's always growing, but I'm happy to take suggestions. So if you run across one, email me. Chuck, comment?
Matt, can I ask you and the group a quick question off topic?
For sure.
I wanted to sign up again for DocuSign. Just as far as for convenience of, sending out, other documents and what we're maybe finding in Sky Slope. Does anyone know, can I re-sign up back with DocuSign and retrieve my old account with the documents that used to be there?
Dan has an answer.
I'm going to answer that for you there, Matt. There's the DigiSign portion of Sky Slope. That's just as easy as DocuSign is. When you go to load up something, you can click on the button that says no property, and you can just create through DigiSign whatever signature thing you need to get. So it's just as easy through SkySlope/DigiSign as it ever was on DocuSign.
Okay, I'll try that. That's a good tip.
And Chuck, to your question, if that doesn't, work for you, I know that Lisa Fairfax has talked with DocuSign 5 different ways in regards to these exact issues. So she's probably the most
Okay.
definitive source right now.
Okay, good. That's good to know as well. So I'm going to try both. I appreciate it. Good meeting too. Thanks.
All right,
Thanks,
guys.
Dan.
Hey, so Chuck, when you sign into SkySlope's forms, on the top right next to your name, there's the apps with all the little squares. If
Yeah.
you click on that, you should get a DigiSign. You switch to DigiSign, and then you can, you sign in there, and you can go new envelope, and then there's a red box at the top right that says no property. So like,
Okay.
some of this is how I do all the like CCPs and ICAs for our office. Is that so you don't have to tie it to a property, and you can create an envelope, upload your form, and plug in.
Let's be honest, this is what
wherever you want.
Let's be honest, Dan uses this for his rental properties, and he sends his lease agreements via DigiSign to his clients. So,
well, you know what? I have one of those I need to send up today, plus Matt, that hold harmless and another document as well. And I'm so used to using DocuSign and just basically uploading and sending it out there. So I'm just kind of, trying to stay with what's familiar, but it seems like it's been a hassle to get back with DocuSign. And so I don't know all the answers there. So I'll go with that first, Dan, and try it out. I appreciate it.
okay.
Call me if you hit any speed bumps on that, Chuck.
Okay.
Hey,
Thanks,
I've got one more question for you, Matt. I know we're
Yeah.
carrying it over here, but this might be pertinent to the group. In a 1031 exchange, a client wants to sell 2 properties and exchange into one. One of the properties he's selling is in his LLC name. One is in his personal name. Tell me a remedy.
Call an adequate 1031 company.
And you know what's funny? His what do you call it, administrator, the dude that handles it, he was scratching his head. He hit the panic button. He said he didn't know what to do.
My guess is, the end game behind this is tax consequences, right? So whether it's your LLC that you have ownership in, I think ultimately, if you can show that you are, for instance, a single manager entity LLC, my guess is you could lump them in together, but I wouldn't put anything past the government and saying that is a no-fly zone. It seems rational, but I'm going to leave an asterisk for the government.
Yeah, I had a couple ideas about it too. I saw Robert's message. I'm going to check with him too.
Okay.
Great. Thanks, guys.
Thank you all. Have a great day.
Thanks, everyone.